A major U.S. Supreme Court decision could now have serious consequences for green card holders. In its latest ruling, the court made it easier for immigration authorities to deport certain returning permanent residents. The decision gives border officials broader authority to deny re-entry to green card holders who are accused of specific crimes. This landmark ruling comes at a time when immigration policy in the United States is already under intense scrutiny as President Donald Trump's administration continues pushing a broader crackdown on both legal and illegal immigration. Welcome to U.S. Visa News Hub. My name is Mr. Burhan, and today we are breaking down everything you need to know about this decision and what it means for your future. The case involved a green card holder named Muk Choi Lau. In 2012, he was charged in New Jersey with trademark counterfeiting. While those charges were still pending, and before he had been convicted of anything, he took a brief trip to China. When he returned to the United States through JFK Airport in June 2012, immigration officials placed him on immigration parole instead of admitting him as a returning permanent resident. A border officer asked him about the pending charge. Lau denied committing a crime, but the officer still confiscated his green card and placed him in parole status. He was kept in this limbo for years until he was eventually convicted of counterfeiting. Only then did the government begin removal proceedings, using the stricter inadmissibility standard rather than the deportability standard that would normally apply to a lawful permanent resident. Lau challenged that decision, arguing that immigration officials should have to present clear and convincing evidence before taking such action. The Second Circuit Court of Appeals initially agreed with him, but the Supreme Court has now reversed that decision. On June 23, 2026, the Supreme Court issued a 6-3 ruling in Blanche v. Lau. Justice Clarence Thomas wrote the majority opinion, joined by Chief Justice Roberts and Justices Alito, Gorsuch, Kavanaugh, and Barrett. The court said immigration authorities do not have to conclusively prove that a returning green card holder committed a disqualifying crime before denying re-entry. Instead, it held that if officials have reason to believe an offense was committed, that can be enough to deny re-entry, seize the green card, place the returning resident on parole, and move forward with deportation proceedings. The Immigration and Nationality Act, the court said, does not impose a clear and convincing evidence requirement on border officers at the port of entry. This video is for informational purposes only. Please consult a qualified immigration attorney for advice specific to your situation. Although the ruling came from one specific case, its impact could extend much further for permanent residents across the country. Under current U.S. law, green card holders who leave the country briefly are generally allowed to return and are treated as already admitted. However, there is an important exception if they are found to have committed crimes involving moral turpitude, including offenses such as fraud, theft, or counterfeiting. They can be stopped from coming back and subjected to inadmissibility proceedings rather than the more protective deportability track. The distinction matters enormously. Under the deportability track, the government bears a higher burden of proof, and permanent residents have stronger procedural protections. Under the inadmissibility track, which this ruling now makes easier to apply, the government can move more quickly and the protections are fewer. This decision could have a major impact on green card holders overall. According to the latest data, around 6.7 million Indians, including people of Indian origin, were living in the U.S., and more than 64,000 Indians received green cards in 2024 out of 1.36 million new green cards issued that year. The ruling affects not just Indian nationals, but all 12.8 million lawful permanent residents across the country. Anyone who travels internationally while facing a pending criminal charge, a past arrest, or any unresolved legal matter. Not everyone agrees with the court's decision. Justices Ketanji Brown Jackson, Sonia Sotomayor, and Elena Kagan all dissented. Justice Jackson wrote a sharp 14-page dissenting opinion, warning that the ruling gives the government too much unchecked power. She said the court has handed the government a massive blank check, allowing it to return a lawful permanent resident to the status of seeking admission upon entry at the border, so long as the government is able to show later that they were eventually convicted. She warned that this sequencing undermines the plain terms and basic operation of the law, and that border agents now have broad discretion to place lawful permanent residents in immigration limbo based on nothing more than a pending charge that may ultimately be dismissed or result in acquittal. Critics say the ruling could open the door to misuse because it relies heavily on immigration officials' judgment rather than requiring completed criminal proof at the border. A lawful permanent resident could now have their green card confiscated, be placed on parole, and face removal proceedings, all before any conviction ever happens. The American Immigration Council warned that at a minimum, border officers will treat more LPRs as applicants for admission based only on pending criminal charges, and those LPRs will face legal limbo while their criminal proceedings move forward. The ruling also left open several questions that the government will likely push to expand, including whether the same lower evidence standard applies to the other 5 exceptions that can trigger inadmissibility proceedings for returning permanent residents. As a result, this decision may affect travel choices for millions of permanent residents, especially those with unresolved criminal allegations, past arrests, or prior convictions. If you are a green card holder and you have any criminal history, even a minor charge, even something you believe was resolved years ago, you should consult an experienced immigration attorney before traveling outside the United States. An immigration attorney can review your record, assess your risk under the new Blanche versus Lau standard, and advise you on whether it is safe to travel and what precautions to take. With immigration policy continuing to shift in the U.S., the big question now is how this ruling will affect the future security and rights of green card holders. And the honest answer is that the full impact will unfold over months and years as border officers, immigration courts, and federal judges apply this new standard to cases across the country. U.S. Visa News Hub provides immigration news and general information only. Always consult a qualified immigration attorney before making any decisions about your travel or immigration case. Official guidance available at uscis.gov and travel.state.gov. If this video helped you understand this important ruling, please like it and share it with every green card holder you know who travels internationally. Subscribe to U.S. Visa News Hub and turn on the notification bell so you never miss a critical immigration update. My name is Mr. Burhan. Stay informed, stay protected, and we will see you in the next video.